So please feel free to move closer into the horseshoe. No need to be shy this morning. So again, can I please invite everyone to sit in the 2 rows of horseshoes? Thank you so much. So good morning. How are we for the last day? So the end is in sight, a long day, a long 4 days of environmental law, which even as an environmental lawyer may be enough for even the hardiest of souls. My name is Matthew Baird. I'm standing in for Kun Viruit, who is unfortunately unwell, from WWF, the Mekong for the Future program, supported by USAID. So yesterday, I think we had some very, very exciting and interesting sessions. I know there was a lot of discussion, whether it was over plastics or climate justice. What else did we do? Oceans, environmental defenders, and one of my favourites, litigation on air pollution. So today, although for those who are the subject of the cases, maybe they don't appreciate as much. But I do find, you know, one of the exciting things is being able to share experiences and to ensure that our mobile phones are on silent during the last. But this day is also about networking. It's also about getting feedback from people over one of the really exciting projects that is occurring at the moment in ASEAN, which is the development through the ASEAN Intergovernmental Commission on Human Rights, or AICHA, and the establishment of a working group to look at an environmental rights framework for ASEAN, which I think in and of itself is a very interesting and extraordinary opportunity for ASEAN to once again show its leadership in environmental law and environmental rights. For me as an environmental lawyer, one of the things coming into ASEAN 13 years ago and working in the region is to realise the extraordinary depth, capacity, experience and understanding of the challenges that we face in environmental law and in environmental rights. And so I think this particular program that we will be discussing today, and indeed seeking feedback from people through breakout sessions, is going to be something that will hopefully excite and energise governments, NGOs and even the private sector over the next year and a half. And it's a great tribute to the ASEAN Intergovernmental Commission on Human Rights for their leadership in environmental law, but also, you know, throughout the work that they've done on human rights over the years that they've been in existence. So we are here today. We are going to first hear from one of our great supporters for the conference, USAID. I also would like to disclose that I have worked as a consultant on USAID projects over many years. My first experience was actually with the PACT, the Mekong Partnership on the Environment, which back in 2014, under the leadership of Christy Owen, decided to bring together civil society and decision makers in the Mekong region for a drafting and development of guidelines on public participation in environmental impact assessment. And I still remember Christy, who has led other projects supported by USAID. She would do an image of landing. One of the European Space Agency had landed a satellite on a comet, which she labelled to like landing a washing machine on a very fast-moving object. But she talked about how the impossible can be made possible. And in the context of the Mekong Partnership on the Environment, when we first brought together civil society with government representatives of the Mekong on environmental impact assessment, the first meeting was, well, we have nothing in common. We are not sure we should be talking to CSOs. And by the end of the 3 years, through a process of consensus building and trust building, we had developed some draft guidelines on environmental impact assessment, public participation on EIA in the Mekong region. So something that initially we thought could not be done certainly became a consensus document. One of the great champions there was His Excellency Dan Saray, who at that stage was Director or Deputy Director of the EIA Department in Cambodia, who is now, I think, taking a position as Director General of the department. And again, it showed to me the leadership that was shown around the Mekong region at that time, for environmental impact assessment for public participation. That was also something that the ASEAN Intergovernmental Commission on Human Rights focused on, the idea of trying to make EIA more responsive to human rights, to climate change, and how they could be included in the EIA process. And that has developed into this idea for an environmental rights framework in ASEAN. And it is an ambitious project. And one of the great supporters of that is USAID. So I would now like to introduce Brad Arsenault to make some introductory comments and welcome comments. He is the Deputy Office Director of the Regional Environment Office for USAID RDMA. He is a Foreign Service Officer and joined USAID in 2008. He has served in Afghanistan, Cambodia and Kenya in a range of positions. Prior to joining USAID, Mr. Arsenault spent 10 years working for development and humanitarian organisations in Africa and the Caucasus, and he began his international career as a Peace Corps volunteer in Gabon. Brad holds a Master's degree in Strategic Studies from the US Army War College and a Master's degree in Urban Planning and Policy from the University of Illinois at Chicago. Brad, please.
Thank you so much. Thank you so much, Matthew. Really wonderful to be here and see old friends and meet new people. Rocky, nice to meet you in person finally, and thank you for having me. As Matthew said, Brad Arsenault. I'm with the USAID Regional Development Mission for Asia, based here in Bangkok, working with Kun Rashane over here on my right. Also wonderful to meet some Cambodian colleagues. My time in Cambodia was some of the best times of my life. I think from 2011 to 15 I was there, and knew His Excellency Sai Samal, the Minister of Environment, there when he had started. And to Matthew's point, I remember when EIA was starting out with the Mekong Partnership for the Environment, and how important that was and how exciting that was at the time. And it's hard to believe that was 10 years ago already. But like Matthew said, it takes a lot of work, it takes time, and it takes partnership and trust building. And so I'm grateful to be here and see everyone continuing that journey today. Also great to see several partner organizations here working on these critical issues of environmental rights. And I want to thank the United Nations, the Asia Research Institute for Environmental Law, Earth Rights International, and of course WWF, and for your promotion of human rights and protecting human rights in the ASEAN region. I also want to recognize our keynote speaker, Professor Amra Bongsapit, the Thailand representative for the ASEAN Intergovernmental. Oh, I'm sorry, my bad. Dr. Aisha Biden, I hope I'm saying your name correctly. Sorry about that. Yeah, no worries. To continue the Intergovernmental Commission for Human Rights and chair of the ASEAN Working Group on Environmental Rights. And I'm sure together in collaboration, you'll continue this important work with the Mekong for the Future team. So thank you for being here today, and my apologies. And the ASEAN region, as we know, is unique in its diversity in every way: mountains, rivers, oceans, forest. And nature and people in the ASEAN region have sustained each other and worked in harmony with nature for centuries. But we know that over-exploitation and unsustainable practices are pushing nature and people to their limits that are no longer sustainable. So threats to nature and livelihoods are often transboundary in nature and often devastating. We see that every day when we wake up. I do, at least, when I read the papers and listen to the news, and it's disconcerting. So a higher level of intervention is essential to support those affected by natural resource exploitation. And ASEAN is central in addressing these regional and transboundary issues, creating changes from local, national, or regional. ASEAN development partners and civil society as a whole must act together to address these unprecedented social and environmental challenges. And the US government believes that human rights protection is an essential component. of nature protection and restoration, and that environmental rights are critical to protect people and foster sustainable development. And this vision is shared by the United States and our partners, and it will guide our actions as it has been. And the U.S. Mekong for the Future, which is implemented by WWF, works closely with ASEAN, civil society, environmental human rights defenders, and other international organizations that support environmental rights. And protecting and promoting human and environmental rights is a complex matter, and it requires working in partnership. Lawyers, journalists, academics, advocates, environmentalists, and human rights experts are all here today collaborating to share ideas and discuss substantive and procedural rights. And I hope that all of you will go home today and back to your countries and feel encouraged. And I hope you know that you have the United States government support and, of course, USAID support, as well as all of our partners that we mentioned, the United Nations, the Asia Research Institute for Environmental Law, Earth Rights International, and WWF, and all the other allies. And I hope that you'll keep promoting and protecting these rights and pushing the boundaries and doing the best that you can, and know that you have us in partnerships and that you have the support you need. So thank you for your support and for being here, and wish you all the best for the rest of the conference. Thank you.
Thank you very much, Brad. So this morning we have two keynote speakers. We have Dr. Aisha Bindin, who I will introduce in a moment, who will talk on some of the issues on ASEAN and environmental rights, and the Deputy Director of the Asian Research Institute and a member of the working group on the ASEAN Environmental Rights Framework, Rocky Guzman, who will also talk about some of the elements within the proposed environmental rights framework. But it would be now my great pleasure to introduce our next keynote speaker for this morning, Professor Dr. Aisha Bindin, who has an extraordinary background in human rights and environmental law in a broad sense of the word. So, Dr. Aisha, I hope you will allow me to read out a little bit of your CV. So Professor Aisha is currently the Malaysian representative to the ASEAN Intergovernmental Commission on Human Rights from 2022 to present. She is also a law professor and a fellow of the Academy of Science in Malaysia. Among the projects that she was involved in the Academy of Science of Malaysia is reviewing the national policy on science, technology and innovation, strengthening the environmental governance in Malaysia, review of the Environmental Quality Act of Malaysia, local and transboundary pollution, national nuclear technology policy, and currently on the National Planetary Health Action Plan. She has also served as a Human Rights Commissioner on the Human Rights Commission of Malaysia, so HAKM, namely as the Commissioner in charge for the Law and International Treaties Division from 2013 to 2019, in which her portfolio also consists on business and human rights and investigation into human rights violation, including complaints on the environment. She was the former Dean of the Faculty of Law of the National University of Malaysia, UKM, and former legal advisor of the UKM Holdings, the corporate arm of the University of Malaysia. Dr. Aisha has also held the office as Commissioner Board Member of the Malaysian Companies Commission of Malaysia from 2011 to 2019. And apart from her work as a law professor, she has been involved in various consultancy projects on law reform and legal policies, whereas she has advised government, ministries, public and private sector, and international organisations. So it's with great pleasure that I would call Dr. Aisha to the screen to deliver your address. Thank you very much.
Yes, good morning to all. Thank you, Matthew, for that very generous introduction. Mr. Brett Arsenault from USAID, Dr. Matthew Bird from Ariel, and Mr. Rocky Guzman as well. First and foremost, I would like to congratulate the organizer for hosting this very important event, the ASEAN Environmental Conference of Law. And I also like to thank them for inviting me to present this keynote speech today in this important event. The session for this morning is on environmental rights in ASEAN and consultation on the ASEAN Environmental Framework. My topic will be on environmental rights and cooperation in ASEAN, issues and challenges. As such, I would like to start by saying that ASEAN's decades of experience in environmental cooperation over pollution issues in particular can serve as lessons for future environmental framework. I will highlight two major points in my speech, namely access to environmental justice as a crucial component for environmental framework, and the importance of environmental cooperation in resolving environmental issues, focusing on the haze issue in ASEAN. First, access to environmental justice. Public participation is an indispensable part in proper implementation process in the field of environmental laws. There is a growing call for greater public participation in environmental issues, particularly in the enforced process of environmental laws. Public participation can play a crucial role in the enforcement of environmental matters through ensuring right to access to information, right to participate, and right to access to effective justice. Principle 10 of the Rio Declaration, which I believe has been extensively discussed in the last few days, is one of the most important part touching upon the right of access to information and public participation. In Europe, the Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters was adopted in 1998, or popularly known as the Aarhus Convention. Though it is an European convention, the principles specified in this convention can be applicable to all countries as its standards bear international character. This is also a very important area, point of reference in the work of coming up with an environmental regional framework for ASEAN. Without ensuring effective access to justice, proper enforcement of environmental law through participation is not possible. It is well-known fact that getting justice is expensive, as it involves many administrative processes which requires monetary and financial sacrifice. There are many reasons for poor people to turn their back on the normal judicial process. The most important reason, among others, is the poor and illiterate people are refraining themselves from a normal litigation due to economic costs, and they are more likely unable to initiate a legal process. Moreover, it can also not be denied that the poor are inclined to fear different kinds of abuse of authority. So therefore, in order to provide proper justice to all, public interest litigation is being allowed in some countries. An area of course is also crucial and new in ASEAN. For environmental protection, the public interest litigation is an alternative to normal challenge to access to justice is working well, as many countries have witnessed it. It is important for the public, who are the beneficiaries of any ill effects of poorly planned development, to be given an opportunity to participate in the decision-making process, which gives rise to the role of environmental human rights defenders. However, in many situations, the interested members of the public are often not allowed to participate owing to the strict rule of standing or local standi. In Malaysia, the Bakun Dam case is a glaring example of the position assumed by the Malaysian courts in dealing with issues of standing. NGOs such as Consumer Association of Penang, Sahabat Alam Malaysia, Malaysian National Society, and many more are actively involved in highlighting environmental degradation issues. However, these organizations are often not given the right to participate for lack of standing or sufficient interest to challenge an environmental breach. This will greatly dampen the evolution of environmental advocacy groups that would effectively mobilize public opinion and resources for the protection of the environment. Hence, providing access to information for the public is important, as it is not possible to comment on any proposed development activity without relevant information. This is tied closely to the issue of transparency and accountability on the part of the administrative bodies empowered to implement the environmental protection measures. Number two, the importance of cooperation on environmental matters among ASEAN member states. And within this context, I've taken the haze issue, which involve transboundary issues and transboundary cooperation as an illustration. Regional cooperation over transboundary haze has been relatively more streamlined under the ASEAN framework. ASEAN as an organization began to acknowledge haze as a regional concern in 1985 with the adoption of the Agreement on the Conservation of Nature and Nature Resources, which specifically referred to air pollution and transfrontier environmental effects. At the suggestion of the ASEAN Chair of Environmental Affairs in 1997, the ASEAN Ministerial Meeting on Haze was established. This marked the beginning of the specific regionalism of haze mitigation at the ASEAN level, with the haze being given a special status of importance in the organization, separate from other transboundary environmental issues. The meeting formulated the Regional Haze Action Plan, which provide further commitments and detail to the cooperation plan. Member states in ASEAN generally avoid legal binding agreements on environmental and haze matters. However, we have witnessed the 1997-1998 haze episode, which was one of the most severe the region has seen, sparked renewed outcry from the public and civil society. These backlash prompted member states to agree to establish a legally binding mechanism to address haze and appease civil society. Therefore, in 2001, the ASEAN Agreement on Transboundary Haze, or ATHP, was proposed to provide legally binding support for the Regional Haze Action Plan. Hence, the ATHP is notable for being one of the very few legal binding ASEAN environmental agreements to be entered into force. Despite its shortcoming, the ASEAN ways of haze collaboration, which includes enshrining sovereignty and non-interference, can be regarded as a pioneering achievement that can be a global model for handling transboundary issues, as the haze cooperation within ASEAN can definitely be said to be more institutionalized. Haze is a term collective accepted and used by all ASEAN member states, and it's formally defined as the ASEAN level as sufficient smoke, dust, moisture, and vapor suspended into air to impair visibility. It is transboundary when its density and extent is so great that it remains at measurable levels after crossing into another country's airspace. So in general, there are, of course, important components, which are factors that can actually encourage environmental cooperation, which we can draw from the haze situation. This consists of 4 factors. 1, there must be a mechanism for policy dialogues. 2, there must be a mechanism for translating science-based input into initiative. 3, there must be channels for engagement with related stakeholders. And 4, there must be an atmosphere for shared ownership. And I think these are the areas that are covered within the haze situation in the region. Further, I think ASEAN also have a special feature that is the ASEAN Way norm, which is enshrined in the ASEAN Charter and the ASEAN Human Rights Declaration and the Treaty of Amity and Cooperation, which prescribes how regional interaction should be carried out. These include consensus, the principles of sensitivity and politeness, a non-confrontational negotiation process behind the scenes discussion, and an emphasis on informal and non-legalistic procedures non-interference, and flexibility. As a result, environmental cooperation in ASEAN and over haze in particular can be characterized as well institutionalized and centralized. So ASEAN has prioritized overarching institutional agreements over haze, and any bilateral mechanism are subsumed under the regional mechanism. For example, the Singapore-Jambi and Malaysia-Riau collaboration under the ATHP Adopt A District program. The haze is a good example of how ASEAN countries cooperate on a key regional issue, because this is something that we will have to figure out and work out regarding the proposed the ASEAN Environmental Region Framework. How can that cooperation be done at the ASEAN level? While the ASEAN haze regime is quite extensive, this does not mean that it is without flaws or shortcomings, because we are aware that currently haze events have not abated in the region. Furthermore, a few recent events related to transboundary haze cooperation have also threatened some internal unity. For instance, Indonesia's long non-ratification of the haze agreement after a while, although they finally decided to ratify. And of course, Singapore's unilateral passing of their Transboundary Haze Pollution Act 2014. Other factors which are considered also that affect the efficacy of the issues is: one, there's no sanction provision for non-compliance. Number two, the progress of hotspot monitoring is hindered by the hesitation of governments to share their vital information relating to territorial integrity and sovereignty. Three, ASEAN member states did not strictly enforce their national law due to the dereliction of duty by the concerned authorities, and also overlapping jurisdiction by agency pertaining to the issues at hand. Four, some incapability of the ASEAN member states to make appropriate intervention when it comes to conflict between environmental management and resource development. And finally, the lack of integrated approach for full cooperation of all relevant sectorial bodies. For instance, we are aware of the lack of engagement with some private sectors and local communities to raise awareness and cooperation. So in general, the ASEAN member states are directly affected by other problems of pollution, loss of diversity, and more extremely climate change impact. These create negative and often significant impacts on people's health and well-being, infringing upon their fundamental human rights to life. While some ASEAN member states might have better legal protection for environmental rights, others might have more limitations in the implementation process. For example, Indonesia has listed in its constitution the right to a healthy environment, which might facilitate its actual implementation. In Malaysia, we have now very serious discussion about this particular right to healthy environment as well. But most other ASEAN member states lack similar constitutional or legal provisions and protection. As a conclusion, ASEAN as a regional organization can play a role in strengthening ASEAN centrality by showing great leadership in developing regional solutions to regional issues. What more, vulnerable groups will also be disproportionately affected when environmental rights are contravened, including indigenous people, women, children, and the vulnerable and marginalized communities. Implementing environmental rights as human rights in ASEAN will certainly be challenging. We are aware of that. ASEAN member state is dominated by a combination of different political systems, various cultural and moral constructs, and different reactions to dealing with human rights. ASEAN consists of 10 different countries with some similar and differences in terms of historical, legal, political, and security background and their own culture, and have its own share of human rights challenges. And not all ASEAN member states have their own national human rights institution. The different political system of the ASEAN member state would approach environmental rights as human rights in different ways. We must be able to accept that because it's based on their political frameworks. International and regional efforts have been taken to accord environmental rights the same fundamental and protection as human rights. For example, the Latin America and the Caribbean countries have signed the 2018 Escazú Agreement, the first regional environment treaty aiming to protect the right of every person in present and future generations to live in a healthy environment and to sustainable development. In ASEAN, there is no general regional agreement on environmental rights and obligation, but there is the ASEAN Agreement on Transboundary Haze Pollution, which is an illustration of how collaboration among the ASEAN member states can be achieved to protect environmental rights. By proposing solutions to these issues based on internal model of environmental cooperation, as being shown in some of the examples that I've given, ASEAN centrality can be also be strengthened by enhancing its internal unity and common voice on this key regional issue, namely the important work that we are doing now, namely towards an environmental regional framework for ASEAN. Thank you very much.
Thank you very, very much, Professor Aisha Bindin. And thank you very much for the great presentation in terms of the role of ASEAN centrality in the ASEAN way, and for the optimistic, positive conclusion that while not easy, there is a lot of opportunities. And indeed, with the ASEAN framework or the ASEAN Haze Agreement celebrating its 20th year of coming into effect when it came into effect following the signatory of Thailand 20 years ago. So at the end of this year is the 20th anniversary of the ASEAN Haze Agreement. So thank you again, Professor Aisha, for your words. We now move to Rocky Guzman, who's the Deputy Director of the Asian Research Institute for Environmental Law. He will talk now a little bit further about some of the details within the ASEAN Environmental Rights Framework to date. He is an environmental lawyer and policy specialist with extensive backgrounds on oceans and environmental rights. Rocky has worked and conducted research on topics from marine conservation and strengthening the rule of environmental law to fisheries management and plastic pollution. He was previously the policy campaigner of Oceania in the Philippines and has been involved in different environmental issues with the Asian Development Bank, the United Nations Environment Programme, and the Sustainable Ocean Alliance. Rocky obtained his degree in law and political science from the University of the Philippines and a master in environmental policy from Duke University. Rocky, the mic is yours.
Thank you very much, Matthew, for that introduction. Just to be clear, my full name here is Roger Joseph Sarah Guzman. It's my full name, but please call me Rocky. And I'm very happy to be here today, not just because it's a very happy occasion. It's the only day holding us back from tonight and tomorrow, the weekend, but also because this is a very interesting and exciting topic, and I think it's relevant for all of us here in the ASEAN region, the Environmental Rights Framework. But first, let me start by saying my thanks and for the rousing addresses by Brad and Professor Dr. Dato Aisha Bindin. I think it gives a good context on what we're going to talk about the whole day on the ASEAN Environmental Rights Framework. And today I'm tasked to discuss a little bit more about what this framework is. So if I could kindly request to flash the presentation. So my presentation is on the details or more general considerations for an ASEAN Environmental Rights Framework. Just some context also, as Matthew mentioned, I'm sitting as one of the, as a part of the working group of the ASEAN Environmental Rights Framework, along with Matthew, who's also acting as a special advisor. So I could give some insights on what has been happening in the past few years as we move towards this environmental rights framework. Now, just some context on what this is. I know we've heard a lot of things about this in the past few days on the nexus of human rights and the environment, but let me just reiterate that sustainable environmental governance cannot exist without the establishment and respect for human rights. Human rights cannot be enjoyed without a safe, clean, healthy, and sustainable environment. Mind these four adjectives, as this is being used again and again, and will be used in the ASEAN context: safe, clean, healthy, and sustainable. Now, what we're talking about today is environmental rights in general. Now, environmental rights are composed of two things, which is substantive rights, which are the fundamental rights that each and every one of us has. This includes the right to a healthy environment, and more specifically, right to clean air, breathe clean air, a right to healthy oceans, a non-toxic environment, all these that we have as a fundamental human right. And we also have procedural rights. These are the rights that are necessary to achieve substantive rights. These include access rights, namely access to information and having meaningful public participation on decision-making for environmental matters, as well as access to effective remedy. Now, this environmental rights framework is an initiative that is led by the ASEAN Intergovernmental Commission on Human Rights. Professor Aisha Bidin is one of the commissioners there, and we have, the ICHR has constituted an environmental rights working group to achieve a holistic approach and enhance the coherence of the regional framework. Now, this will be a very ASEAN-specific framework, but this draws from a lot of international experiences and regional agreements as well that are already in place across the world. Now, what is this and where are we in the process of establishing this environmental rights framework? So right now, we are in the process of creating the form and content that is being undertaken through collaborative discussion by the ASEAN Working Group. So the ASEAN Working Group is composed of a number of experts and also ASEAN regional bodies, as well as CSOs and vulnerable groups across ASEAN. Now, again, as I've mentioned, it draws on many experiences already that are already in place in other jurisdictions, specifically on other regional access rights agreements as well, in Europe and in the Latin America and the Caribbean. Now, what I'm going to discuss here briefly is to give you context for what we're going to do in the next few hours on the interactive session. So I'm going to discuss the key principles, the substantive elements, and what this might look like as we discuss this and potential options, as well as the procedural elements for this environmental rights framework. So just to give you a lowdown of what elements we are considering for this framework, we have, of course, the introductory elements, which will be discussing the environmental law principles derived from both human rights and environmental rights law. And then we have the huge chunk on the operative elements. Now, this will compose of a discussion of substantive environmental rights, procedural environmental rights or access rights, which I'm going to discuss more about, a special segment on environmental human rights defenders, as this is a huge issue in the ASEAN region. Now, this framework is also special because it deals with thematic issues. It does not really solely focus on procedural environmental rights. This also covers matters on implementation of laws on terrestrial, atmospheric, coastal, and marine environments, and also specific groups such as vulnerable groups as women, IPs, indigenous people, youth, and children. Now, it also encapsulates some tools and mechanisms that we use to implement these access environmental rights, including EIA, SEA, or Strategic Environmental Assessment for Programs and Policies. And specifically for ASEAN, it's very relevant, is transboundary environmental impact assessments, as well as environmental standards for different topics, including air quality, water quality, and all these environmental issues. Now, for implementation, this is quite important because as of the moment, the form is that it's an environmental rights framework, but we have not discussed on what it might evolve into later on. Would it be a different instrument? Would it be an agreement or convention? We have to recognize that there are challenges on having a more on it being a convention or an ASEAN agreement. But at this moment, we are using the environmental rights framework as its form. And to implement this framework, we have provisions on actors in civil society and how these actors could cooperate at the regional level for the implementation of these environmental rights. Just a brief, I just want to show you a brief on the overarching law principles of the Environmental Rights Framework. Again, as I've said, this is derived from both human rights and environmental law. At the top, you could see the general principles for environmental law in general, as can be seen in multilateral environmental agreements, equality, transparency, and accountability. Of course, we have to have meaningful public participation, and we always have to act in good faith in implementing these provisions. Then we have environmental law principles that are derived from a lot of multilateral environmental agreements. We have the preventive principle, precautionary principle, you have heard this a lot in the past 2 days, intergenerational equity, for the present and future generations, and also polluter pays principle. We also have some principles derived from human rights law, including the universality of human rights, that each and every one of us has an inherent human right that have to be respected and have to be fully implemented. And as to access to information, there's also the principle of maximum disclosure, that to disclose as much as possible what we want, so that everyone can meaningfully participate in decision making for environmental matters. And in ASEAN in particular, we have the non-regression and progressive realization, as we have to keep moving forward and not regress and deteriorate the regimes that we already have right now. So just quickly on the substantive elements, these are some of the substantive elements that will be discussed and considered in the drafting of the Environmental Rights Framework. As I've said, we have the overarching substantive right of a right to clean, healthy, sustainable environment. But John Knox also fleshed out these substantive rights. John Knox is the former rapporteur for human rights and the environment. As composed of the right to a clean air, safe climate, healthy ecosystems, safe and sufficient water, healthy food, and a non-toxic environment. Now, some of these substantive elements might look like implementing these environmental law principles and enhancing EIA, SEA, but specifically for ASEAN, this framework, it would also look at implementing these substantive rights to support vulnerable groups in particular, and protect specific parts of the environment, including biodiversity, oceans, and fisheries. So all these will be discussed or will be considered in the drafting of the Environmental Rights Framework. Just to show you how things look in implementing the right to a healthy environment in ASEAN, we have in 2022, last year, the UNGA has already passed a resolution for a right that everyone has a right to a clean, healthy, and sustainable environment. Note these three adjectives: clean, healthy, and sustainable environment. Doesn't have safe for some reasons, but in the ASEAN context, it's even better because the ASEAN Human Rights Declaration already has the adjective safe attached to a healthy environment even before. This was passed in 2013. So putting all these things together, we have in the ASEAN context a right to a safe, healthy, clean, and sustainable environment, and that completes the reference to a right to a healthy environment for ASEAN. Now, what does this mean for the national jurisdiction, national context, and for every one of us here? The potential national legal reforms that could happen that would cascade and would be derived from this environmental rights framework is that there would be adoption of a right to a healthy environment and the implementation of environmental commitments under different MEAs. And this is also what we want to get more from you in the interactive discussions on what would be the needs and what would be the potential judicial and legal reforms that could happen if we have an environmental rights framework in place. Now, for the procedural elements. I've mentioned earlier that there are a number of regional agreements that are implementing environmental rights in general. We have the Aarhus Convention for Europe and the Escazú Agreement for the Latin America and the Caribbean. But now we want to have this one as a cornerstone of the environmental rights framework. The legal foundation for this, of course, is the Principle 10 of Rio Declaration, which posits the three fundamental access rights. This is what we call the key pillars of sound environmental governance. These procedural rights are the access to information, access to public participation in decision-making for environmental matters, and access to justice or access to effective remedy. Now, That's the three original one from the Principle 10 of Rio Declaration, and that has been also enshrined in the Aarhus Convention. But subsequent regional developments further elaborate on one more procedural environmental right, and that is to have a safe and enabling environment. And this is particularly for environmental and human rights defenders. That was enshrined in the Escazú Agreement, which became effective in 2021. So those are the four procedural environmental rights. You can see at the right side there. And some procedural elements might be, aside from those, promoting FPIC, FPIC, free and prior informed consent for indigenous communities, for instance, and providing special attention to vulnerable groups, and of course, support to our environmental and human rights defenders. Just a quick lowdown on the references for the procedural environmental rights. As I've mentioned, the Rio Declaration. We also have the Framework Principles on Human Rights and the Environment, or the NOx principles, which restates all these principles that we have in different MEAs, and also principles from human rights and from the nexus of human rights and the environment. As I've mentioned, we have the Aarhus Convention, which became effective in 2001. That is of focus on Europe, but is open also for ratification from other jurisdictions as well. And they have presence in Africa and Central Asia already. In Latin America, they have the Escazú Agreement, which is a very, very progressive instrument, as it focuses, aside from the three access rights, on protecting environmental human rights and defenders through having a safe and enabling environment for them to exercise their rights. And specifically for EIA and SEA, we have agreements such as the ESPO Convention and the Kyiv Protocol, which we can draw experiences from to ensure that there's meaningful public participation in these environmental impact assessments. Now, again, what does this mean for every one of us here at the national level? For access to information, this could mean that the Environmental Rights Framework could instigate in defining environmental information more broadly and in alignment with the principle of maximum disclosure. And it would mean that environmental information would be disseminated more clearly, and it would mean also restrictions of reasons for denial so that everyone can have grounds for getting information, either pulling information from government or government pushing their information on their own, as this is a matter of public significance. Now, for public participation decision-making, this also could mean that there would be more robust environmental impact assessments, also strategic environmental assessments for programs and policies. In terms of for indigenous peoples, we have to secure FPIC, or free prior informed consent, having more clear guidelines for identification of stakeholders and ensuring that all vulnerable groups are included in the process, and to ensure that we create really effective platforms for public participation and not just a pro forma one, and make it really meaningful and for everyone to have to publicly participate in the process. For access to justice and remedies, we've heard about it a lot in the past 3 days. But I would really like to highlight the importance of this and the importance of having, for example, green courts, environment courts, and tribunals that are focused on environmental issues and environmental litigation, and strengthening judicial systems to ensure accountability. Now, this could also be in the form of adopting rules of procedure for environmental cases, which would have provisions on anti-SLAPP or strategic lawsuits against public participation or harassment suits, and establishing the right to compensation for damage from environmental harm. Very important to have this, to have an enabling environment for the public and human rights defenders to exercise their rights. And the last one, as I've mentioned, is the enablement of a safe and healthy environment. This includes introducing legislation to protect the rights of EHRDs and actually recognizing the work that they do, and amending existing laws that might be discriminatory against EHRDs, such as defamation and trespassing. Now, national regimes should also prevent and investigate extrajudicial killings and attacks against EHRDs. And one way of doing this is expanding the role of NHRIs, or National Human Rights Institutions, in environmental matters. So this enabling a safe and healthy environment would cover EHRDs, but would also cover each and every one of us, like the public, that we also have the right to freedom of expression and association, and we can exercise these rights on environmental matters freely and without restrictions, denial, or impunity. As I conclude, I just want to emphasize that this regional approach provides the impetus, really, for developing environmental rights enabling an environment for environmental rights, and every one of us could exercise these rights freely in the ASEAN region. It recognized the 5 pillars, as I've mentioned, the substantive elements, and the 4 procedural elements. And the Escazú Agreement can be seen as a guide for developing countries and regions in ASEAN to emulate. And this would eventually necessitate reforms at the national level in policy, regulation, and judicial procedure to uphold our environmental rights. Now, in all of these, the most important at this stage is to engage more people, stakeholders, and public participation, and make sure that it's a meaningful process in the establishment of this environmental rights framework. And I'm very happy to be here today to discuss this with you, and we'll be hearing more of you later on what your thoughts are on this environmental rights framework. And for this, I've prepared just a QR code where people could get more information on what this means, and we could we could update you on the developments on the environmental rights framework. So if you could click like and subscribe, the QR code here behind me, and that would be great, and we would be happy to share with you the developments of the environmental rights framework. So with that, I end my presentation. I'd be happy to take more of your questions, but I'll be also roving around later in the interactive sessions to get more of your thoughts on what we're doing at the ASEAN level. Again, thank you very much. And Matthew, over to you.
Thank you. So can we leave the QR? We can leave the QR code of the last. Yes. So please, what was it? Share, like, and subscribe. Thank you very much indeed, Rocky. And again, thank Professor Dato Dr. Aisha Bindin. She has to leave, and Professor Bindin will actually be in Bangkok next week when the first meeting of the working group on the ASEAN Environmental Rights Framework will be held in this location. Thank you very much again to the United Nations, UN ESCAP, UN Environment Programme, and the supporters for that, including I think the Swedish Environment Development Agency. So we have a few moments for some questions, if anyone would like to ask Rocky, or indeed Brad has agreed to sit and ask questions. If there are any questions from the floor before we do 2 things. One is that we'll have a little bit of an explanation about the next stage. As Rocky's mentioned, we'll be going into some discussions and breakout groups. And also we will have another group photo. And we'll have the group photo here at the podium. But before we do that, are there any questions or comments or observations that anyone would like to make? Please, the floor, the mics are open. Please.
Thank you for your interesting presentation. In our Constitution, we recognize environmental rights for the citizen, for the human. It says that everyone has the right to live in a clean environment and has the obligation to protect the environment. So that the right always together with the obligation. So if you in your presentation, I saw that it not have the slide to talk about the obligation, the environmental obligation. Because if you have right, it means that you have obligation to respond, to adapt, to respond to the other, because the other have the right. The other right is your obligation. So that the obligation in the environmental, what is this, and how we can enforce the other can do their obligation. Thank you.
Thank you. Any other comments and questions before I open up to, and observations, please? Yes.
Hello, my name is Rati and I'm from Cambodia. I just want I heard that you said like you've been engaging with CSO, vulnerable communities, indigenous communities, all of that. And what is the progress of the framework now? And also like, is there any possibility and opportunity for other CSOs to engage in drafting or providing some comments to this agreement.
Thank you. Any other comments before I, yes, please.
Good morning, everyone. I'm Jim from the Philippines. With regard to the ASEAN Environmental Rights Framework, we just want to know if there are certain aspects or elements of the framework that the technical working group has anticipated to perhaps be vulnerable or be receiving some form of resistance or difficulty in terms of acceptance, implementation, or enforcement in some jurisdictions of the ASEAN region?
Thank you. I can take one more and then I'll, any.
Sure. Thank you for a lot of questions, and I'm glad that there's a lot of interest on what's happening now in the environmental rights framework. On the first query, the delegate of Vietnam on the rights and obligations, yes, indeed, it's important not just to recognize that we have these rights, but also for the duty bearers to have to actually implement these obligations because they have these rights enshrined. Right now, at the stage, we don't have, we're not yet in the process of getting the draft out, and that draft will have the wording on how the rights might look like. So for now, because of it's an environmental rights framework, it might look like most ASEAN agreements, like states can endeavor or will take their best steps to ensure that there is an enabling environment, for example. But this could also mean, this could also be, that's a possibility, but there's also a possibility to have more mandatory provisions, such as the provisions in the Escazú Agreement or the Aarhus Convention, that states shall take necessary measures and implement and have necessary judicial reform to implement their environmental rights and access rights in their respective regimes. So that's something that will have to be discussed by the technical working group. And this is also related to what the instrument would look like. Would it be a framework or would it be more of a convention? So that's something that will have to be discussed further. But in any case, there is always the obligation of governments to implement these human rights, and drawing from experiences from other jurisdictions. For example, for Aarhus Convention and the Escazú Agreement, they have their implementation mechanisms. This includes having a compliance committee, so it's not really scaring the governments that you have to do this. This is non-confrontational, non-adversarial, that you're not doing this and you have sanctions. It's more of facilitating compliance and making sure that governments take the necessary measures that would align with the access rights provisions in those respective instruments. And that might be something that could be included in the implementation provisions of this environmental rights framework. So I guess that's for the first question. Shall I continue? Okay. For the second one on the CSOs and indigenous communities and vulnerable groups, I've mentioned this is really, in terms of stakeholder engagement, this is one of the cornerstone that we have to really look at engaging. Now, at the process right now is we're actually having the first technical working group meeting formally next week. We've had a number of technical working group meetings in the past, inception meetings, and an inaugural one last year. But right now, it's institutionalized already by the ICHR in the ASEAN level. So we have formally our technical working group that will be convened next week. And one of the agenda items there is the stakeholder engagement process. And definitely, one of the tracks that we're looking at in the engagement process is to look at CSOs and engaging them to make sure that they have inputs in the process. So CSOs would also include a track on environmental human rights defenders groups. They have networks here on EHRDs. And aside from CSOs, we also have a track on environmental law groups. as well as regional bodies as well. So rest assured that this has been discussed, and this will be discussed in thorough detail in next agenda, and hopefully we'll have a stakeholder engagement that will be endorsed and will be ready to be implemented in the next few months, leading to the development of a zero draft in the next, possibly next working group meeting. So yes, that's why if you want to be updated, scan this behind me, because we will be updating you on the developments, especially for CSOs and other vulnerable groups on this process. I feel like I've been talking a lot, but the third question on so what are the aspects that the TWG is anticipating to meet resistance on? Now, as Professor Aisha mentioned, ASEAN, we recognize at ASEAN that we have challenges. We have a lot of similarities, but we also have a lot of differences in terms of regimes and how we interpret environmental law and specifically human rights law. In some regimes, human rights law might be touchier than others. So we are trying to frame this really as an environmental issue and not solely a human rights issue. There are some reservations on using a lot of human rights terms, but really this is intertwined with environmental rights, and we just have to frame it so that it's palatable to all, but it should still be implemented, and the core elements of having human rights as the center of this environmental rights framework should be there. It's more of just discussing further with the technical working group and getting more inputs from stakeholders that we have to have an agreement on the provisions. But that's something that we will be looking at in the next few months in the technical working group and in the consultations for stakeholders. So, yeah.
And thank you, Rocky. And in relation to that consultation, as Rocky mentioned, the working group meeting is considering a draft stakeholder engagement plan, and hopefully, if that is approved and adopted, then the formal processes of engagement will occur. There have also been a number of meetings held. The Philippine National Human Rights Commission has held a meeting. The Thai National Human Rights Commission has held 2 meetings. And the Malaysian Human Rights Commission has also held a meeting looking at the discussion about principles and issues in a more general way. It is expected, with support from USAID for the Mekong for the Future, and also from UN agencies and the Swedish Environment Development Agency, that there will be considerable discussion and engagement over the next year. But today, there is also an opportunity to engage and participate. And so part of the idea of today is to then focus in the morning on 2 issues, namely the enabling environment and environmental human rights defenders, and then in the afternoon after lunch to look at some of those procedural elements, access to information in environmental matters, public participation, and access to justice or access to effective remedies in environmental matters. And so what we will be asking people to do after our group photo and the break is to move into the meeting room, which is set up with tables of 6 to 8, and I think that will accommodate everyone. And then Rocky and Georgina will lead and facilitate some discussion on those practical recommendations and suggestions that we will then fold back in to the consultation process. So we would urge everyone today to think about how practically we can start to discuss environmental rights and what that actually means. And there have already been a number of really key issues raised already during the course of the last few days. In particular, one issue when we were discussing the strategic litigation against public participation, the use of particular litigation about environmental defenders. We heard from John in the Philippines talking about how they work with local prosecutors so that the charges of criminal defamation or criminal trespass are not laid before the court. So they don't activate an anti-SLAPP provision of the court, but the prosecutors themselves can exercise their discretion to identify this particular case as being meeting the criteria of actually trying to interfere in the procedural or people exercising their environmental and human rights. And so that was one particular element that emerged, and there are others talking about how we can actually identify these rights and exercise them. Professor Aisha also talked about the access to justice, how people can actually access, whether it's the formal court system or other forms of mediation or dispute resolution mechanisms before it gets to court, how they can access both attorneys and the processes to ensure that those rights are protected. And so today is also about exploring all of those options, and in particular with our law students, thinking about how that can also work for education, for example, how we can educate and develop capacity within both communities, within CSOs, and within governments on how we exercise and enforce those environmental rights. And as also the distinguished delegate from Vietnam mentioned, many countries in this region do have constitutional provisions in relation to environmental rights and framing those, but how those obligations can be enforced. Both the United States and Australia, we don't have an environmental right, and yet there are many people trying to identify that in state constitutions, and certainly these are something that is emerging, this idea of environmental constitutionalism, and there is a great report on that that was prepared by the UN Environment Programme. Also within the region, we acknowledge that there are significant and wonderful legislative reforms. For example, the Environmental and Natural Resources Code of Cambodia, after a lengthy process of discussion, negotiation, there was 6 years of negotiations around the terms of the code, and that has recently, before the last election, was passed by the National Assembly. And how that is implemented will be a challenge as any implementation of environmental law is, but this is also very exciting because that code also has introduced key principles in environmental law. Again, I also disclose that myself and many others, including Attorney Mehta here, were engaged through that process over many years with the Vishnu Law Group and the Ministry of Environment, working and BJ Schulte from Earth Rights International and others were engaged. Many national and international experts were engaged in this quite extensive process. So I'm actually very proud that it has been passed. But the implementation of environmental laws is always a challenge. So thank you again very much. Thank you, Rocky, and thank you, Professor Aisha, for your presentations. Again, I would like to thank Brad for being here and for USAID, and also for Roshan, to thank you very much for coming along and participating. And now we would like to have a group photo, and again, we'll come up here and we will, I think, take a photo from there for the last day of the event, and then we will have a break. And then I would invite everyone to go into the meeting room around the corner where Rocky and Georgie will lead and provide some guiding questions for the discussions and the workshops there on environmental rights. Thank you so much. We'll come in the middle. And can I also